I would like to cordially welcome you to the International Scientific Conference entitled Contemporary Problems of Criminal Procedure. This is already our fourth conference devoted to the contemporary problems of the criminal process, which we have the opportunity to organize as the Scientific Circle of Criminal Procedure Law, but it is the first one with an international character on this subject. We saw the need to broaden the research perspective with international elements and to enable the exchange of experiences between scientists, researchers, and practitioners from different countries. I would like to thank the honorary patrons of today's event who decide to support our scientific initiative. I would like to give special thanks to Ministry of Justice, National Prosecutor Office Attorney General Bogdan Święczkowski, Institute of Justice, Ferenc Madl Institute of Comparative Law in Budapest, Institute of Forensic Expertise of Professor Dr. Jan Zen in Krakow, Foreign Intelligence Agency in Poland, Dean of the Faculty of Law and Administration of Opole University, and Dean of the Faculty of Law and Administration of Cardinal Stefan Wyszyński University. The aim of the event is to analyze the legal regulation concerning the issues of the contemporary criminal proceedings. The deliberations of the conference will become a unique opportunity to consider the perspective of the directions of development of criminal procedural law, as well as an attempt to define the differences and similarities between the legal orders of modern countries with regard to criminal proceedings. The event is an international scientific conference, therefore I hope that the presented papers will be an important source of information in terms of good practices and applicable legal solutions, focusing of the issues of the criminal process, which are the center of comparative legal studies. I hope that the conference will become an opportunity to create a platform for discussion and exchange of views and experiences regarding the contemporary criminal process. Without extending the start, thank you so much for a great interest in the event. I wish you a successful conference and fruitful reflections. So I'm looking at the agenda, and the first panel will be led by Mrs. Klaudia Uniewska. And in this moment, Klaudia, please take the floor.
Thank you, Professor. My name is Klaudia Uniewska, and I represent the Cardinal Stefan Wyszyński University in Warsaw. During today's conference, I will be the moderator of this panel. The first speaker will be Professor Marcin Wielec from the Cardinal Stefan Wyszyński University in Warsaw, who will present a paper entitled Functions of Values in Criminal Procedure. Professor, please start your speech.
So I am speaking now again. And my introduction is a function of values in criminal proceedings. So, dear colleagues, in my opinion, today little attention is paid to the fact that linking the issue of values with criminal proceedings is primary issues, because values are one of the fundamental issues for the overall justification of the existence of criminal proceedings. Consequently, values, all values in connect to criminal proceeding are or not, or rather should be, the first and essential, albeit abstract and invisible, unseen elements influencing the entire structure of criminal proceedings. Values, of course, stem from the nature of humanity. First, society recognized values, gives them a specific content, and then allows and sometimes even forces their universal respect. And hence, it is close to the legal level in which specific orders and prohibitions to behave by community members are concentrated. It has long been forgotten, affirming the ubiquitous legalism of law, that it is otherwise law, this is the carrier of various values. Values are not extended important determinant assessment made and standards of conduct of community members. Values transferred to criminal procedure should be the main determinant of the construction of the model of criminal proceedings. In this approach, the values are to influence its shape and course and set strict and impassable boundaries for function taken in criminal proceedings. Only this and so much. Those values on the basis of criminal proceedings will be those timeless and common models of attitudes and behaviors, the implementation of which should be required, for example, from the most important decision-making participants in criminal proceeding. Ultimately, it must be conducted that the values, and more precisely their presence and implementation mainly in the provision of criminal proceedings, determine the quality of criminal proceedings in general. The more the model of this type of behavior is constructed on the basis universal values, which will again be understood and defined in accordance with their natural purpose, then more criminal proceedings will be legally and socially understandable and necessary. Therefore, undoubtedly, the values and more precisely the possibilities of their implementation and their achievement in the area of criminal proceedings should first of all determine and shape in the legislator a specific model of criminal proceedings. According to my proprietary scale, my individual scale of value connect with criminal procedure, their value will be dignity, rule of law, justice, truth, trust, security, honesty, and morality. The correct construction of a model criminal proceedings and then its proper functioning depends precisely on the proper recognition and ensuring real possibilities of realizing the above-mentioned values, which are characteristic of the procedural and criminal area. Because values, as they are assumed on the axiological plan, are everything that is valuable and desirable, and what is the goal of human aspiration, which is considered important and favorable and implemented in the same way. Thus, the main function of value, there is creation. Straight line values affect the behavior model. Depending on the values respected in criminal proceedings, such will be criminal proceedings, pure criminal proceedings. There are many arguments in favor of treating value in criminal proceedings as the main elements of creating a specific model of criminal proceedings. I distinguish several such arguments. The first argument I call the guarantee-warranty argument. In a democratic system, society adheres a certain values and thus directly or indirectly relate to criminal proceedings. Their preoccupation with the procedural criminal law system creates ambivalent protection for the individual against potential stronger organs of criminal procedure. Therefore, if we assume that one of the basic values in society is inter alia, justice or true respect for life and ensuring the safety of citizens, it is clear that is the area of criminal proceedings, certain general mechanism must be determined, which will actually implement the signals values. The absorption of values into the provisions of criminal procedure is the context of the guarantee argument, allows the values to meet them. It seemed that the natural role of universal guarantees of absolute compliance by the stronger subject with its prerogatives seems to be natural. The guarantee arguments therefore justifies the need to implement the values in criminal proceedings from the point of view of the stronger entities in terms of organization and competencies, respecting the procedural guarantees of the weaker individual. The second argument is the limitation argument, which is understood as setting by respecting certain values a uniform border for the above-mentioned procedural interference in the life of individuals, which is mainly for procedural authorities. The powers vested in the authorities acting in criminal proceedings may never be equated with the consent to the unconditional and limitless violation of human rights and guarantees. It is characteristic of the specific of criminal proceedings that they appear frequently the temptation to the proverbial shortcuts and use the instrument of repression reserved only for the state for a completely subjective purpose. It is the values through the present limitation argument that set the objective boundaries for the state's activities in the area of criminal proceedings. The limitation argument sets the limits of admissibility of interference by state authorities in criminal proceedings. The third argument is the legislative argument, which is derived from the general framework and principles of legislation in the state. Anyway, it seems that the whole matter with the legislative argument related to the issue of value realization has a much wider context than just the area of criminal proceedings. It turns out that in the current legal status referring to widely understood legislation, there is an official order that respects in creating all normative acts certain values already recognized in society. The legislative argument is about demonstrating that in the legislative process, there are certain pre-imposed criteria from sociological areas that must be taken into account when creating a normative act and which refer directly to the issue of values. And the last, the fourth argument is the creative argument, based on the assumption that active and real respecting and realization of values in criminal proceedings needs an institutional approach to them. The creative argument then implies the emergence of the new institution and procedural solution procured by the implementation of certain values. This is related to the previously analyzed connotation that exists between certain values and the times in which they were formed, as well as the model of criminal proceedings developed on the basis of these two factors, including more and more new threats that required a criminal reaction or new types of crime that appeared now, forced the state authorities to develop new mechanisms, because in example, the value of depreciate. In example, introducing new institution in criminal procedure, such as European arrest warrant, crown witness, and anonymous witness. So from my side is all. Thank you for your attention. I wish all again fruitful discussion. Thank you. Claudia, the floor is yours.
Professor, thank you for presenting your paper. Now the next speaker will be Roland Szymczykiewicz, who will present a paper entitled Lack of Preventive Measures in Case of Fake News or Insult in Polish Criminal Procedure.
Hello, everybody. Thank you very much for passing me the voice. I hope I can be heard well. Well, first of all, I would like to say that it's a great pleasure to be here and to attend in this conference. And now I shall present the results of my small research I've made about the Polish criminal procedure. Well, first of all, at the beginning, I'd like to say that, of course, Polish penal procedure has a lot of in common in all the other European procedures, as the basic values have been mentioned, but also according to the rules of the penal procedure. And I'd like to just mention the rule of two instances, that there need to be two instances run in the court, and of course the presumption of innocence, which will be very important for the next part of my speech. It is obvious that we have a part called investigation, and then when the investigation is finished and there's the act of somebody is accused, then we have the trial at the court, and it has two parts, because of course the defendant has the right to appeal. So basing on this fact, we have to consider that also sometimes there happens such a situation that there comes a need to protect the trial, to protect the investigation, and from actions from third parties, which may interrupt the investigation. And of course, we have something called preventive measures, and preventive measures are well known also in other procedures, of course, and they are, our penal code says, and penal procedure code defines some of those preventive measures. And for example, we have, of course, arrest, which is ordered by the court, and we have some other means such as police supervision. We have bail. We have a warrant to leave the country. That's connected with the topic I'd like to speak about. I mean, events happening in the internet. If I get lost, continuing on, I have titled my presentation "Lack of Preventive Measures in Case of Fake News or Insult in Polish Criminal Procedure." Well, I will admit honestly that the part connected with fake news is, of course, to be catchy, but as you will see, there are some serious problems connected with it. But before moving on, I also want to say one more important thing. Due last years, Polish criminal procedure has been changing, and there's an idea which we are following, that the trial should deal with all problems, all consequences that are caused by the crime. What I mean, we have not only the mission to find out the suspect, to catch him and to find him guilty. So that's what the trial about. But also, what's very important, and what's also a rule, we have to take care of the victims. And by taking care of the victims, we also mean ordering some damage repair. It can be in money, or it can be in nature by fixing something. And of course, the compensation payment for mental suffering and such situations. So we have to take care of the victim, and let's make a quote, clean up the situation and all the evil that has been done by a crime. And my research shows that there's a gap. There's a legal gap, because our regulations are not suitable for all types of crimes, especially those connected with the internet. As I've mentioned, the title that I'll be talking about is, am I heardable now? Yeah, okay. But it's not, my intention is not to mistake somebody, but the problem is that fake news has no definition, no legal definition. We may rather say about disinformation. It's a very huge, big topic, and a lot of behaviors can be classified as fake news. And there's, of course, as a result that there's no definition of fake news, there's no direct crime connected to fake news, to preparing fake news, for passing it further. But we have some behaviors in our penal procedure that for sure can fulfill that definition or be a part of it. And one of it is defamation. And it's clear that if we write or say about something, someone, especially if it's connected with his job and it's on the internet, it may cause real serious damage, not only in the virtual world, but also in the real world. Let's imagine a situation that on a website, somebody writes about a company and says that the owner cheats everybody, that the products are not good, that he was serviced in an awful way, and that the clients are treated in a very bad way, and that nobody should ever use this company. Yes, nobody should ever become a customer of it. This is not an innocent opinion. It's an opinion that may even destroy that company and cause real serious damages. And now it can be considered as a type of defamation, that somebody is being treated, or said, it is said that somebody is a cheater, that he's unfair, that he's not running his company the way he should. So we can run a penal court for defamation. If there are any words that insult somebody, we can also run a penal process for insults, because it may happen that they are considered also part of such a negative opinion. And what happens next? What's the problem? The problem is that the penal procedure has no means that can be used, no legal tools to block the information on the internet on a website, to block the website, eventually to order some sort of information, to put an information that there's a trial running on and that somebody feels hurt, and then somebody feels accused, maybe not accused, but somebody found it unfair and found it that he has been a victim of defamation on the website. And what turns out? It turns out that there are no such means, because our list of preventive measures is closed and there's no such element for the penal court. Of course, after the trial finishes, there is a way that the court can order a damage repair. It can order also compensation, but it is after the penal process finishes, and of course, in the case that somebody is found guilty. The process may last for months or even longer. It happens in different ways. And the question is, the big question is, what's in the meantime? What's during the process? And it seems out on the way of using penal process, we can't do nothing. Of course, the person who feels that has been a victim of defamation can go to a civil court. This is, of course, his right. He may fight for his personal rights, but it's a different type of process. It has its own rules, the evidence rules, and also it costs. And it would result in such a case that somebody has to run two cases, one in civil court and one in penal court, in order to receive some help. The civil court, of course, has such cognition, has such right to give an interim, to block a website, to block something that is written on a website or on a forum or something like that. And the penal court doesn't have it, doesn't have such a tool. And that's the main idea of my research, to show you that there's a lack and that there are some missing preventive measures. There should be a possibility for the penal court, on the demanding of the prosecutor or demanding of the person who's feeling that he's a victim, because mainly defamation and insults are run by the victims by themselves. They put their own, they press their own charges to the penal court, and they should have the possibility to ask the court to order blocking such a text in the website, eventually blocking the website, or at least ordering the person to put in information that there's a trial running on and that somebody feels that he's been a victim, so that everybody who reads it knows that it's not just a fact that somebody, for example, is unfair, but he will see that there's a process, and that will make him think, and hopefully will prevent from all the bad results about such defamation things that are written due the internet. So as I've mentioned, it's some kind of a gap of in the tools in the Polish penal procedure, and it should be somehow repaired by the parliament, and there should be the change of law in order to react for such behaviors, for such events that happens in the internet, because it has a huge power and it can destroy people's careers, it can destroy companies, and really do a lot of harm. So for the time of the court trial, the penal trial, there should be a legal tool for the court to stop it. And then, of course, if somebody is found not guilty and proves that he wrote the truth, there's no reason why the text cannot come back. But for the moment, it is not. Yes?
Yes, 1 minute left.
Yeah, thank you very much. I was just going straight to the end of my speech. So, as I said, there's a lack, there's a gap, and it should be filled, and the penal court also should have such legal tools. And I found that it should be preservative measures, as I've mentioned. Thank you very much for my speech. Thank you very much for letting me be here. It's a great honor, and I'll be listening carefully to the next speech, to the next people talking. Thank you very much.
Thank you for presenting your paper. Now the floor will be taken by Bartłomiej Oręziak, who will present a paper entitled the title Judicial Assessment of Electronic Evidence in Cybercrime Cases, Perspective of Poland.
Thank you very much. Ladies and gentlemen, my name is Bartłomiej Oręziak, and I'm a PhD student at the Faculty of Law and Administration of the Cardinal Stefan Wyszyński University in Warsaw. First of all, I would like to thank you for the opportunity to present a paper and congratulate the conference organizers on this initiative. However, going to the merits of today, I will talk about judicial assessment of electronic evidence in cybercrime cases. This will be a perspective of Poland, of course. Ladies and gentlemen, recently, dynamic development of new technologies can be observed in many areas of modern life. Therefore, it can be said that the current technological progress permanently changes most traditional solutions into modern alternatives, which are, of course, assumed to simplify people's life. The criminal trial, in particular the evidentiary proceedings, is not an exception to this process. This is because the evidentiary procedure can be attributed of extraordinary sensitivity to innovation processes. Such a situation does not seem to be peculiar, because if you think about it, the entire criminal trial from its beginning to its end is guided by its basic goal. This goal is to realize the value of truth and fulfill its subject, that is in principle to determine the legal responsibility of the accused for the alleged offense. Therefore, it seems natural to take advantage of the benefits of technological technical progress in accordance with the criminal procedural law, with compliance, of course. Sometimes in a criminal trial, we deal with specific prohibited acts. This is, for example, cyber crimes. We are also talking about having them evidenced in the courtroom. This is the aim. In this case, electronic evidence, in my opinion, is the only one way to make correct factual findings and then to accurately concretize the abstract set of signs of a crime. By the way, the aforementioned conditions of compliance with the norms of procedural criminal law is highly important, as evidence obtained unlawfully in certain situations should be considered inadmissible. And now, okay, but what in fact is electronic evidence? Ladies and gentlemen, the European Union Agency for Network and Information Security notes that most definitions of electronic evidence identify the concept in question with digital data that can be used to establish or disapprove whatever the accused has committed a crime. And of course, this is true, and it is good observation, a suggestion, or just proposal, but it tells us more about the purpose of electronic evidence in a criminal trial. But in my opinion, the very definition of them, of electronic evidence, is rather all objects in cyberspace that provide evidence in a court trial. And now go to the question, does electronic evidence have a place in the Polish criminal trial? The answer is yes, of course. The admissibility of introducing electronic evidence results from the lack of the so-called formal theory of evidence in the Polish criminal trial. And in the other hand, in compliance with the Cyber Convention of the Council of Europe. This means that it is possible to take any evidence of value significant for the resolutions of the court case. In other words, it is possible to present all the factual circumstances and the realization of the truth as the basic goal of the criminal trial, and thus to fulfill its subject, it is in principle to establish the legal liability of the accused for the alleged offense. Ladies and gentlemen, however, moving on to the main topic of today's presentation, it should be noted that electronic evidence in Poland, like any other evidence, is freely assessed by the procedural bodies conducting the criminal trial in criminal trial. As part of the literature on the subject, it is noted that very evaluation of evidence is a thought process consisting mainly of 4 factors. It is the first, full scope of evidence. This is all resources and sources of evidence. The second, life experience. The fourth, indication of science. And the fourth, it is the rules of formal logic. Ladies and gentlemen, the implementation of all the above factors in the Polish criminal trial result directly from Article 7 of the Code of Criminal Procedure, according to which the authorities in charge of proceedings shall base their certainty on all examined evidence apprised at their own discretion, with due consideration to the principles of sound reasoning, knowledge standards, and personal experience. However, the situation becomes complicated when the court analyzes extensive evidence, the extensive materials, and therefore the jurisprudence indicates that the court's conviction that some evidence is credible and the others are unreliable is protected by procedural law. This happens only when it is preceded by the disclosure of the entirety of the circumstances of the act during the trial and in a manner dictated by the obligation to seek the truth. The conviction in question is the result of considering all the circumstances, both in favor and against the accused, and is exhaustively and logically argued in the justification. Ladies and gentlemen, factual findings do not exceed the principle of the free assessment of evidence only when they were made on the basis of a comprehensive analysis of the evidence submitted. and their assessment does not show errors or factual or logical nature, is consistent with the indications of knowledge and life experience, and leads to the judge's conviction, which should be reflected in the justification of the judgment. In this justification of the court's judgment, an analysis of the evidence must be carried out, showing the premises on which, from among many different divergent evidence, the court based its findings and conclusions. However, it should be borne in mind that the assessment of electronic evidence may sometimes require a procedural authority with highly specialized knowledge that it will not normally possess. In such a situation, it is possible in Poland, pursuant to Article 193, paragraph 1 of the Code of Criminal Procedure, to appoint an expert or experts. Ladies and gentlemen, this means that the Polish criminal trial remains open to the potential of electronic evidence, which is a current challenge, contemporary challenge. On the other hand, the probative value of electronic evidence is assessed on the basis of traditional principles, rules provided for typical evidence in a criminal trial, with the provision, of course, that if it is justified by the complexity of reading the data contained in the electronic evidence, the court may appoint an expert who will present the data in an accessible form. Based on these data, court will freely assess the evidence. It is very important now that the experts does not assess the probative value of this evidence, but only present data. It is, for example, contained in a binary code. In Polish criminal proceedings, only the court has competence to assess the evidential value of evidence. And now I would like to conclude my paper with this observation, and thank you very much for your attention. Thank you very much.
Thank you, Mr. Oręsiak. Now I would like to welcome Professor Derencinovic, excuse me for my spelling, from the University of Zagreb, who will present a paper under the title Current Issues in Croatian Criminal Law and Procedure.
Well, thank you very much. Good morning to you and to everyone. It's not a problem with my last name. It's really quite long and complicated to pronounce. I'm glad to be here. I'm grateful to the organizers to take part in this very interesting and very important event dealing with the current issues in criminal law and criminal procedure. I myself, I'm professor of substantive criminal law at the University of Zagreb, Faculty of Law, but from time to time, I do take excursions into the law on criminal procedure. And when I was basically reporting the potential topic, I was not sure what exactly I will be speaking about, because there are so many interesting and challenging topics in Croatian, in current contemporary Croatian criminal procedure. But at the end, because I realized that I have, well, 10 minutes or even less, that I have to pick one specific topic, and I decided to address very briefly some developments concerning the transposition of the Victims' Rights Directive of the European Union in our legislation, but also in practice. So, as you all know, because most of you are professors or other teachers actually who deal, or PhD students who deal with the criminal law and criminal procedure, it is important to say that a very important part of the process of democratization is this development of the human rights, which has been reflected on the area, on the field of the criminal law. And one of those, I would say, developments is no doubt the affirmation of the position of the victim in a criminal proceedings. As we all know, the criminal proceedings have been, well, historically focused on the perpetrator as the central figure of the criminal proceedings, but from the 20th centuries onwards, the victims are being more and more seen as those who are also very relevant in the context of the criminal proceedings. And for that reason, this renaissance of the position of the victim was firstly introduced by the framework decision that was adopted back in 2001 in the EU, and then it was substituted, it was replaced with a directive from 2012, and that directive basically extended the position, well, improved the position of the victim within the criminal proceedings by extending substantive rights of the victims concerning rights to be informed, rights to challenge the decision of the public prosecutor on discontinuation of the criminal proceedings, right to get a compensation or at least to claim a compensation in a criminal case, right to interpretation and a translation, right to individual assessment, right to protection from secondary victimization, and so on and so forth. And speaking about a directive, well, all countries, all member states of the EU were in obligation to harmonize their legislation until 16th of November 2015. This is also an obligation for those countries who have status of the candidates or who are negotiating with the EU just right now. And Croatia, who joined the EU in 2013, was also in obligation to align its legislation, but also practice with this particular directive, also with other directives on the compensation of the victim, directive on the fight against terrorism, and so on and so forth. All those directives are very important pieces of legislation of the so-called Brussels law concerning the criminal procedure, and have to be taken holistically in assessing the level of the alignment of the national legislation with requirements under those instruments. So what is important and what are the provisions that have been implemented in our national Code of Criminal Procedure? First of all, definition of the victim. It is very important to include both direct victim and indirect victim, including the members of the family, the partners, and all the others. Those who suffered indirectly from the fact that a person was victimized, that was subjected, or that against the person the criminal offense was committed. Then right to information that encompasses three different aspects. First of all, it's the first contact information about the rights of the victim, about the position of the victim, and it's very important that those who are in first contact with the victim, being police or the public prosecutor, state attorney office, give all those information on leaflet, for instance, or in some other appropriate way to the victim of crime. Then it is very important that a victim gets the written confirmation on the criminal complaint, because it was not a case, prior the transposition of the directive in our Code of Criminal Procedure. Even after that, just after that, we changed our Code of Criminal Proceedings in 2017 to make sure that a victim will, in all cases, get this written confirmation, and also all other relevant information. For instance, the fact that the perpetrator, who is a convict now, for instance, escaped from prison or released on either conditional released or after the full execution of a sentence, and so on and so forth. So it's very important, because in practice we have had some issues in how to appropriately implement this obligation under the directive, because it was not quite clear actually who is in obligation, the court, the judge of execution, the prison administration, or someone else to forward this kind of information to a victim. Then again, another very, very important right of the victim is to get the support from either NGOs or some offices that are established at courts but also to avoid secondary victimization, to give a right to be heard during the criminal proceedings without unnecessary repetitions, because as we know, unnecessary repetitions of the examination, of interrogation of the victims in the course of criminal proceedings could lead to a secondary victimization. Then the access to the to those offices for support, right to get a compensation, right to challenge the decision of the public prosecutor on discontinuation of the proceedings, to either hire a public prosecutor office or to a court. This could be done through implementing the institutes of the so-called subsidiary prosecutor that we have now for decades in our criminal proceeding architecture of our criminal proceedings. And it is possible for the victim, basically, if the public prosecutor decides not to continue the criminal proceedings, to decide in 8 days, in a week, basically, whether he or she will overtake the proceedings or not. And last but not least, it is very important, and there are some lessons learned from the jurisprudence, from some problems that we are facing in everyday application of those standards. It's not important just to have a legislation, but to provide for effective implementation of the legislation when it comes to this directive. Very briefly, for instance, we have some sort of hybrid system when it comes to this support on courts. For instance, we have 15 courts on which this directive should be implemented, but only on 7 of them we have this specially established offices. But on 8 of the other courts, especially in the rural areas, in more remote areas, there are no such offices, but the NGOs provide for their assistance. Though the problem is that in the rural areas at the small courts, there have been no sufficient NGOs who can provide basically the victims with the support. There is also a problem of the expertise. At most of these offices, we mostly have, well, the lawyers, not enough social workers, not enough psychologists, and the other who can provide the support. Then statistics about it. This is also very important, you know, to have very accurate, but also very systematic statistics on this. Of course, it is very important to provide necessary financial resources for that, and so on and so forth. So this is very important, in addition to the legislation that has to reflect, that has to mirror requirements under the directive, to provide its efficient implementation in practice. And there are some lessons learned actually in Croatia. I think that the others can learn from some mistakes we did in this regard, because I think that we have very good legislation, but we have to work on its full implementation. So since I have very little time, I think I will stop now. Looking forward to any of your questions or comments. And thank you very much for your attention.
Professor, thank you for presenting your paper. It was an extremely interesting speech, so thank you. The first panel of the conference has already ended, and it's time for a short break. The second panel will start according to the agenda, so at 11 o'clock. Thank you very much.